Back on the program with me is Tulsa County District Attorney Steve Kunzweiler, speaking unedited about lots of topics. Thanks for coming back. I appreciate it.
Thank you. I appreciate that.
I do want to start with the Charlie Kirk assassination. I know you've been following that a bit, but there has been a lot of talk about the evidence, and I know there have been times when you have not talked to us about evidence and things like that. Are you worried about the way some of this is being handled at all?
Yeah, you know, when you watch this thing, you've interviewed me many times, and a lot of times when I've got a case that's getting ready to go to court, you're like, well, hey, tell us about what happened in this particular case, and you'll get a standard answer from me. It's like, hey, listen, this person is accused of a crime. They enjoy the presumption of innocence. The evidence needs to come out before a judge and a jury. I'm not going to litigate this case in the media. I want to make sure that we can present a proper case before a judge and let the court make that decision. You've heard me say that 100 times. And as I've been watching some of the Kirk case unfold, I'm seeing people reporting about, well, he said this, he confessed to that, or we've got results of DNA testing and it says X, Y, or Z. Those are the types of things that I, as a prosecutor, at least in Oklahoma, am absolutely barred from saying pre-trial. It impacts that presumption of innocence. So, you know, I was biting my tongue and sort of like, oh, please don't be saying that. You know, there's other ways to address evidence and still get your message across. And from my perspective, you know, what Charlie Kirk kind of represented was the protection of constitutional freedoms. You know, I'm Catholic, and so I believe our constitutional freedoms are God-given gifts, and we set up a government to secure those rights. And that's what Charlie was doing, was advocating in essence for the freedom of speech, to be able to talk about something that is a God-given right, and hopefully in a public discourse you get to share ideas and move the country forward. The irony is, to me, is on the one hand, Charlie being an advocate for the protection of constitutional freedoms, and yet I'm seeing other folks invade a whole different other area, the presumption of innocence. There's a bit of an irony to it, but you know, Charlie was a good guy, and I think it's a sad loss for our country.
Let's say this would have happened in Oklahoma. Heaven forbid if something like this does happen. I was shocked that this is a capital case right off the top, or yes, this is death penalty. Was that very fast, or do you kind of know?
Well, so each jurisdiction kind of has different structures to how they might consider doing a death penalty case. In Oklahoma, we have what we call the filing of a bill of particulars. It's not just the murder I have to prove, but I have to prove what we call aggravating circumstances. And it's always been my practice to not make a decision on the death penalty until we've had the preliminary hearing. I want to see how witnesses testify and get more information, because once you know, it's going to be my name on that bill of particulars that says, I think this guy deserves the possibility of the death penalty. So other jurisdictions may be different. They may simply call a murder in the first degree a capital crime. But in Oklahoma, there's several more steps that go into it, and I think you have to be pretty deliberative about that. I try and resist the public pressure, because oftentimes emotions are going to be high. And we're thinking the Charlie Kirk case, obviously they're high. It was probably the most documented assassination ever on video. So it's going to evoke an emotional response, and prosecutors, our jobs are to, let's get that emotion out of there, and let's just decide what can we prove and how are we going to prove it. So, you know, Utah may have a different structure than what we do, but in Oklahoma, I can guarantee you it'd be a lot more deliberative, at least in Tulsa County.
You recently had the April Wilkins case that got a lot of attention, and the Oklahoma Survivors Act. Obviously you came out on top. What do you think a lot of people misunderstood the Survivors Act, and that's why this kind of got attention? Because there were a lot of people who were like, well, she was beaten herself and you know, lived through that, but it seems like there may be a misunderstanding here of the law a little bit.
Well, obviously, it's a statute that was designed to address issues in which you have people who may have been victimized by domestic violence, that perhaps a court should take into consideration whether or not the range of punishment should be as broad as it is. In a murder case, the range of punishment by first-degree murder, the range of punishment is life or life without possibility of parole. If somebody is eligible under the Survivors Act, it's only going to be eligibility determined by a hearing in which a judge listens to the evidence, and that's what the process is designed to do. It's not just saying, hey, I'm eligible. You have to prove or demonstrate that that was a substantial contributing factor that led to the homicide itself. And so, you know, why I believe in this Survivors Act, I think it actually does have merit, and there are going to be occasions in which somebody's homicidal act was a direct result of domestic violence, but it still requires a hearing in which the person who's advocating for that has to be able to prove or demonstrate it. And so I'm going to continue to abide by the process that's a part of that, and that's what I think people expect any prosecutor to do is, you know, let's see where truth and justice falls, and let's put that in a courtroom, and let's vet the facts. You know, one person's version of the facts may be different from another person's, and that's why we hand it over to a judge and say, ultimately, here's what the evidence shows. And the judge made the ruling that he made, and that's the system that we live with.
Is it automatic if I can claim domestic abuse and then I get a hearing?
No, you have to, at least by way of a written application, show that you think that you have the evidence that would be able to be presented to a judge, and that judge will review the written stuff. It's kind of like almost a criminal charge, yeah. Right? You know, I can always say, hey, I think you committed that crime, but then you have to have a hearing in front of a judge or a jury where you actually have direct and cross-examination. It's not just, hey, I'm eligible, here's a piece of paper that says I'm eligible. It has to go through the scrutiny of a trial. That's why we live in the greatest country on the planet, is because we allow the facts to be fully vetted. We just don't take governmental officials or an individual's position and say, well, it has to be so because they say it's so. We afford litigants in a case, a defendant, a plaintiff, the opportunity to challenge the evidence or put forth evidence.
Were you concerned when this became law? I mean, we saw with McGirt, everyone automatically considered themselves to be tribal and tried to apply. Were you concerned about a flood of applications in this case as well?
Yeah, I think at the beginning, as it was originally drafted, and it went through different iterations before it ultimately got passed, and I think it's a good law. I think it's designed to say, well, we're not going to just let anybody get up there and come up and say, hey, I'm a victim. It sets a standard of proof. They have to prove by clear and convincing evidence that they're eligible under the Act. They have to show that it was a substantial contributing factor, and they have to present evidence in a courtroom. They just can't rely on a piece of paper. So at the outset, I think it had to be refined, and it was, and it passed overwhelmingly, and the governor signed it into law, and I certainly support it. But that doesn't mean that just because somebody files an application that I'm just going to roll over. I have a job. I've been hired to represent a case, you know, on any case, whether it's a homicide or not. There's a victim on the other end of that, and my job is, under Marcy's law, is to advocate zealously on behalf of victims of crime, and so we're going to do the job that we were hired to do, and not roll over just because it may be a popular thing to do or the trendy thing to do. You know, my office, you know, when I first became the elected DA, we had one prosecutor handling domestic violence cases. We got 5 or 6 prosecutors handling domestic and sexual assault cases. We are well embedded in trying to advance protecting victims of domestic violence, but at the same time, I'm also required to abide by the rule of law, and I'm going to follow the rules as they were written, even under the Survivors Act. There's a set of rules you have to follow, and I'm going to follow those.
I do want to talk, his first name's escaping me because all I know is that as the Fetters case.
Ronald Fetters.
Yes. This was a gross case. I mean, I just, what is your reaction? And well, we can update folks. He bounced around from Florida and Ohio, and then he came here, but for decades he's had sex with children.
Right. No, yeah. It is the most horrific set of facts that I have ever in my career reviewed. the prosecutors that handled the case, Ashley Nix and Kimberly Jantz, two very seasoned prosecutors, one who handles a lot of juvenile cases, the other handles a lot of the felony cases. When they were discussing this case with me, it was just a shop of horrors. I mean, you couldn't imagine the number of times that Mr. Fetters had access to children, was sexually assaulting them. There were reports being made to local law enforcement and Department of Human Services caseworkers in Florida and Ohio. And it's just like a revolving door. Everybody was pointing the finger at him, and somehow he had the magic to convince people he wasn't doing what he was doing. Ultimately, he ends up in Oklahoma, and when his 19-year-old daughter goes to the hospital and is giving birth to her baby prematurely, they figured out that the baby was the product of incest, that he had impregnated his daughter. And from that, we ended up filing incest charges, but then we went back and was like, well, who is this guy? What's the history? And then you find all these different victims over multiple states, in which it's just a shop of horrors. And so we brought a lot of those witnesses in from those other jurisdictions who were thanking Oklahoma for bringing justice on a case that should never have come to Oklahoma in the first place. If folks had done their job as they should have in those other jurisdictions, we never would have experienced Ronald Fetters.
Well, I was going to ask, and we're running out of time, but does Ohio and Florida want him now that you've kind of put him away?
Well, I would certainly hope that they're going to be reviewing it. I mean, we just got this conviction on this case. We're certainly going to share the information with those authorities. I don't know what their statute of limitations are, but these victims came from far and wide because their lives had been destroyed because of him. I mean, you ask anybody that has worked with women who have suffered sexual abuse, it is a burden they carry with them most of their lives unless they get adequate counseling. And a lot of these women have had difficult lives because of Ronald Fetters. And so bringing some sense of justice to them, that they could see that in 45 minutes it took a jury to find him guilty and give him the maximum punishment, 2 life sentences plus the maximum on incest. I think that was a little bit of closure for them. They could at least see that their perpetrator is going to serve a significant amount of time. Well, actually serve the rest of his life.
Steve, I'm out of time. Thank you so much for stopping by. I appreciate it.
Yep.